Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I'm VP Moolman from Maserumule, and in today's episode we will unpack what if an employee is suspected of being under the influence of alcohol. Can breathalyzer tests be used to prove misconduct? Now, earlier this year, the Labour Court's judgment in the matter of Salmon Core Chrome versus Willemse has stirred up concern and apprehension among employers regarding the continued viability of utilizing breathalyzer tests for detecting alcohol in employees within a workplace. Additionally, there's uncertainty about their efficacy as a means of disciplining or restricting access for employees. Certain news reports have conveyed the notion that employers are now prohibited from terminating employees solely based on a positive breathalyzer test and insist on a blood test as the sole acceptable method of testing. So the question is, are these reports correct or is it simply misleading? Firstly, let's look at the facts of the case. So on 22 February 2019, the employee arrived at work and was asked to take a breathalyzer test on an AlcoBlow rapid machine. The breathalyzer indicated a red light, meaning a positive result. The employee questioned this result and the security officer tested him again on the same breathalyzer with the same result. The employee denied that he had consumed any alcohol either that day or on the previous evening. The employee was then breathalyzed on another machine called the Lion Alcometer 500 by another security officer. The result was again positive and indicate an alcohol content of 0.013%. Now, the employer subscribes to a policy of zero tolerance on alcohol and drugs, and its policy stipulates that a person shall be deemed unfit to enter the premises in the event that their breath alcohol level exceeds 0.000%, or if the drug test indicates any illegal substances. The employee was dismissed on 25 March 2019 after being charged with having tested positive for alcohol. He referred an unfair dismissal dispute to the CCMA. Now, at arbitration, this is the interesting part, the employer led evidence of an expert witness who is a chemical pathologist, and he testified the following. Firstly, a blood sample drawn from the employee was sent to Ampath to test for the presence of alcohol in the employee's blood. He also testified that the method used to determine the blood alcohol content in the sample was a plasma ethanol test, which cannot test for alcohol below 0.010. He said that the report issued by the lab was negative, i.e. it indicated that the employee's blood sample had less than 0.010 alcohol content. He also said that blood test was more accurate than a breathalyzer test, and that breathalyzer tests may be false in certain circumstances. For example, when the person tested had not eaten for more than 8 hours or eaten any substance with a yeast content. He said that in his opinion, the result of the test performed did not mean that the employee did not have any alcohol at all in his blood. It simply meant that there was no blood alcohol content exceeding the 0.010. But for all clinical purposes, the result was indeed negative. Now, at arbitration, the employee called his family medical practitioner and he testified the following. The employee consulted him after he had been accused of consuming alcohol. He took a blood sample from the employee and he sent that to Ampath. The results came back negative. Now, the employee also testified himself. He said that he's fully aware of the employer's policy. He was subjected to the breathalyzer tests as described by the witnesses. He did not consume alcohol on the day in question or on the evening before, and that he consulted his GP who drew the blood or blood sample for analysis. Now, the Commissioner, after considering the evidence presented, found that the chairperson of the disciplinary hearing ought to have taken the laboratory results into consideration, since those are more accurate and reliable. And based on the evidence presented, the arbitrator found that the employee did not breach the employer's policy. The employee's dismissal was found to be substantively unfair and a retrospective reinstatement was awarded. Employer was not happy with this award and therefore filed a review application at the Labour Court. Now, the crux of the review was whether the arbitrator misconstrued the nature of the inquiry and misdirected himself regarding the expert evidence that was led, causing him to reach a decision that a reasonable commissioner would not have reached. The employer submitted at the Labour Court that the arbitrator based his findings on whether the employee was intoxicated, whereas it's not required to demonstrate that the employee was intoxicated or that he was unable to perform his contractual duties at the time. Alternatively, the employer submitted that the nature of the inquiry pertained to the dismissal of an employee for contravening the zero tolerance rule. Now, the court found that the arbitrator's award or the arbitration award clearly records that the employee had been dismissed for having alcohol in his blood and not for intoxication. Therefore, the arbitrator did not misconceive the nature of the inquiry, nor could it be said that the company was denied a fair trial. Finally, the court also found that there was no misdirection by the arbitrator in his assessment of the evidence, as the evidence discloses that after the breathalyzer tests, the employee's blood sample was analyzed by the lab, which produced a negative result. The expert witness, called by the employer, confirmed that the blood test was more reliable than the breathalyzer test and that the negative result of the blood test was correct. Accordingly, the court said, in the absence of any reviewable irregularity in the arbitrator's assessment, the court ultimately found that the review application should be dismissed. Now, colleagues, as a result of the court not finding fault with the arbitrator's analysis of the evidence and the arbitration award rendered in these circumstances, as I've mentioned, many news publications have incorrectly stated that breathalyzer tests can no longer be used to determine whether an employee consumed alcohol in contravention of a clear company policy. In this case, it's important to note that the Labour Court was only required to determine whether the arbitrator made a reasonable decision based on the evidence provided on the day of arbitration. It was not required to determine admissibility of breathalyzer tests or their results. The employer appears to have failed to effectively rebutted the evidence of the employee during the arbitration, which was fatal to its case. Now, while it's widely acknowledged that breathalyzer tests offers employers a convenient means to assess compliance with their alcohol and substance abuse policy, it's equally recognized that their reliability can vary. Hence, when employees dispute the outcomes of these tests, it is advisable for employers to substantiate the results with additional evidence, such as the findings from more precise tests, before making any adverse employment decisions, including any disciplinary measures. This case also highlights the challenges employers may encounter when attempting to enforce a zero-tolerance policy in situations where an employee has only a minimal amount of alcohol in their systems. This is a consideration employers should keep in mind when formulating their policies. So colleagues, that then brings us to the end of this week's episode. Thank you for joining us. We hope you found our discussion informative. If you have any questions or comments, we would love to hear from you. As I've mentioned before, you can find us on social media or email us at info@massconsulting.co.za. I will see you in 2 weeks' time. Bye-bye.